Every day across India, millions of lives brush against the law. Some seek justice, some defend themselves from it. And right in the middle of all that, there's a system. A system built to protect, to punish, and to preserve fairness. But how is it actually structured? I'm your narrator, and today we're opening up one of the most foundational sections of the criminal procedure law, Section 6. And I have 3 people with me today who each bring a completely different perspective to this. Let's go around. Tell our listeners who you are.
Hi, everyone. I'm the analyst. I look at the law from a systems perspective, how it's designed, why it's structured the way it is, and what the logic behind it actually tells us. If there's a pattern or a framework, I want to understand how it holds together. Really glad to be here.
And I'm the practitioner. When the analyst talks about how the law is designed, I'm usually the one saying, okay, but here's what actually happens when you walk through that door. Looking forward to this one.
And I'm the scholar. I research the history and philosophy of criminal justice, in India and across the world. So if the analyst is interested in how the law is built, and the practitioner knows how it feels on the ground, I'm the one asking why it exists the way it does in the first place. Happy to be here.
Perfect. Honestly, this is the panel this topic deserves. Let's get into it. Part 1. The structure, Section 6. So, Section 6 of the Criminal Procedure Law. Analyst, you've looked at this closely. What does it actually say?
So at its core, Section 6 is beautifully simple. It says, apart from the high courts and courts set up under other laws, every Indian state shall have 4 classes of criminal courts. 1. The Court of Session. 2. Judicial magistrates of the first class. 3. Judicial magistrates of the second class. And 4. Executive magistrates. 4 tiers. Deliberate. Each one placed exactly where it needs to be.
Practitioner. Does that match what you see on the ground?
Absolutely. And what the analyst is describing isn't just theory. It's alive every single morning in a courthouse. Cases come in, and before anything else happens, someone has already decided which tier of this system is going to handle this person's fate today. That decision exists because Section 6 drew the map.
And, practitioner, what you're describing on the ground connects to something much older than the criminal procedure law. This kind of layered court structure isn't unique to India at all. Roman law, English common law, colonial-era frameworks across Asia, the same instinct keeps appearing. Divide the courts. Rank them by the gravity of the matter. It is almost a universal principle of organized justice.
But scholar, here's the question I always come back to. Why must justice be divided at all? Why layered? Why ranked? To a lot of our listeners, that might sound cold, mechanical, a hierarchy without a heartbeat.
Narrator, that feeling is worth taking seriously. But I'd say the structure is less about how justice feels and more about how justice gets delivered. Section 6 doesn't decide what is right or wrong. It decides who is best placed to make that determination. And that is a distinction that changes everything.
And scholar, I'd add, I know from the ground up, I've seen what happens when there's no structure. A murder and a minor dispute, same queue, same magistrate. It's not just inefficient. It is genuinely unfair. Chaos doesn't feel neutral when you're the one waiting for justice.
Exactly, practitioner. And from a design perspective, the structure is calibrated to capacity. A sessions court is built, in time, in procedure, in seniority, to carry a trial that could last months or years. You cannot ask that same court to also handle minor disputes in the same breath. The tiers exist so that the weight of each case lands somewhere capable of holding it.
So Section 6 builds the structure, but it doesn't decide which crime goes where. That belongs to Schedule 2. Part 2, the mapping. Schedule 2. Schedule 2, the map that assigns each crime to its court. Analyst, walk us through it.
So Schedule 2 gives us a classification table. For every offense, it answers 3 questions. Is it cognizable, or non-cognizable? Is it bailable or non-bailable? And which court is it triable by? 3 columns. And the logic running through each row is consistent and clean.
Let's take them one by one. Row 1.
Row 1. If an offense is punishable with death, life imprisonment, or imprisonment for more than 7 years, it is cognizable, non-bailable, triable by the Court of Session. The gravest crimes. The highest court. No ambiguity.
Practitioner. What does row 1 look like from inside a courtroom?
Scholar, narrator, that row is murder, rape, dacoity. I've stood in those sessions court proceedings. The weight in the room is different, I'll tell you that. The judge sits higher. The arguments go deeper. The silences last longer. Because the stakes are a person's entire life, and the court knows it. Everyone in that room knows it.
Practitioner, what you're describing is something I find deeply significant. The law mirrors the moral weight of the act. When someone's entire life or liberty hangs in the balance, the highest court in the structure must hear it. There is a philosophical elegance to that alignment. The most serious instrument of justice reserved for its most serious moment.
Row 2.
Row 2. Punishable with imprisonment for 3 years and upwards, but not more than 7. Still cognizable. Still non-bailable. But now triable by a magistrate of the first class. Serious crimes, but not the gravest. A serious court, but not the highest.
Practitioner. What's row 2 like on the ground?
Analyst, this is honestly the tier where I spend most of my time. Serious assault, cheating, certain corruption cases. The magistrate of the first class has real power, real teeth, but the process is faster, more accessible. For ordinary people who cannot afford to lose years of their life to a long trial, this tier is often where justice actually reaches them.
And practitioner, that calibration is, from a historical perspective, the most important balancing act in the structure. If every case required a sessions court, the system would collapse. If sessions courts only ever saw the rarest crimes, citizens would queue endlessly before magistrates. The middle tier creates flow. And in justice, flow is not a luxury. It is oxygen.
Exactly, scholar. The middle tier is the load-bearing part of the whole design.
And row 3, the final row.
Row 3. Punishable with imprisonment for less than 3 years, or, with fine only, non-cognizable, bailable, triable by any magistrate. The lightest offenses. The most accessible court. The widest door.
Practitioner.
This is where I meet the most human stories. A shopkeeper and his neighbor. A young person caught in a minor dispute. The goal isn't punishment. It's resolution. Get them in, hear them properly, help them move forward. Justice wearing its most human face.
And the design supports that, practitioner. Not every shadow deserves the same light. Lesser offenses get a lighter touch, faster resolution, less stigma, more room for the accused to make amends.
Because justice is not a hammer. It is a scale. And a scale must feel the difference in weight. Part 3. Cognizable versus non-cognizable.
There's one more dimension running through that entire table that I want to make sure our listeners understand. Analyst, cognizable versus non-cognizable. Break it down.
So when an offense is cognizable, the law moves first. Police can investigate, arrest, and file an FIR without waiting for any court's permission. The system has momentum built in. It doesn't pause.
Practitioner, have you seen that momentum in action?
Many times. Police at a scene. Arrest made. FIR filed. All before a court has even opened its register for the day. In those moments, the law feels alive in a way that is almost impossible to describe until you've stood there and watched it happen.
But practitioner, The non-cognizable category is equally important, and for a different reason. When an offense is non-cognizable, the citizen must act first. The court must be moved into motion. That requirement for court involvement is a deliberate safeguard, a check against state power acting without oversight on minor matters. And analyst, narrator, this tension between the law's momentum and the citizen's liberty is the oldest tension in every legal system ever built. Schedule 2 tries to hold both in balance.
And yet, the law divides by severity. But the human cost is indivisible.
Narrator, that is exactly what needed to be said. I've seen families torn apart by sessions trials dragging on for 4 years. I've seen people acquitted after years in under-trial detention. The structure is sound. The tears make sense. But the human beings inside it still suffer. And the blueprint, analyst, scholar, it doesn't feel that pain.
Practitioner, no structure is perfect. Section 6 creates the framework, but it cannot create wisdom in those who operate it. A magistrate who rushes, a sessions judge who carries a bias. The architecture cannot fix human failure. That is the system's oldest, deepest limitation.
And scholar, practitioner. I'd be dishonest if I didn't say the data reflects that. Under-trial populations, case backlogs, inconsistent outcomes across districts, real numbers behind real lives. The design is sound, the execution is ongoing, and the work is far from finished.
Whether before a magistrate or a session judge, every accused stands in that courtroom and faces the same eternal question. Did you do it? The court may change with the crime, but the duty to answer justly never changes. Scholar, final thought?
Section 6 is a procedural provision. Dry, technical, a few lines in a code most citizens will never read. But what it enables, millions of judicial decisions every year across every district of this country, that is anything but dry. The ones who carry this law carry something enormous, and most of them do it quietly, every single day.
Practitioner?
I've walked into a courtroom almost every working day for almost several years. Tiny magistrate's court in a quiet town. Gleaming sessions. Court in the middle of a city. They look different. They sound different. But every single time, I feel the same thing. The weight of what the law is trying to do. And despite everything, I think that weight is worth carrying.
Analyst?
The structure exists to make that weight manageable. No single court overwhelmed. No offense unheard. No accused tried by a forum too powerful or too weak for the matter at hand. The design doesn't promise perfection. It promises intention. And in a system this vast, intention is where everything begins.
Because justice is not in the law. It is in those who uphold it.
Every single day.
Every single courtroom.
Every single case.
Thank you to our analyst, our practitioner, and our scholar for one of the most honest conversations we've had on this show. And thank you, wherever you're listening from, for being here. Until next time, take care, everyone.